Judge Shackelford interpreted that there was a breach of contract law on the basis of plaintiff's complaints. It's false.
That it was not a new motor. It was spray painted, make it look like a new motor.
Their insurance company only provided for a remanufactured
On
engine.
the invoice states he said I have a new motor.
Where on that invoice?
A labor description.
Distinguishing the old engine from the new engine.
I asked 2 questions in my thumbnail. Neither answer is cut and dried, but the answer for one is much more apparent to me than the other. This pro se litigant had his car engine replaced by his insurance carrier in 2020. Everything was cool until this year, it seems, but then he sued the shop that did the replacement. We can infer by the timing of his small claim that his engine crapped out after the warranty period expired, and now he thinks he found a loophole in the law that he wants to exploit to score a new one. You may be surprised by the judge's decision. Let's bonus.
This is David Johnson versus Elite Car Care, Inc., case 25011080. And this is a scheduled motion for summary disposition as well as a settlement conference.
Correct. Good morning, Your Honor. David Bianco, Plaintiff.
Good morning, Your Honor. David and Trifina Johnson.
All right. Well, good morning, Mr. Johnson and Mrs. Johnson. All right. And have you two had an opportunity to meet?
I mean, we did, Your Honor. I mean, this is, you know, we had filed our motion for summary disposition, and essentially that's our basis. I mean, my client can't necessarily resolve this and pay the plaintiffs any more because they have no cause of action, and I can get into the arguments when you're ready.
So, yeah, I see that there was a previous order regarding defendant's motion for summary disposition signed by Judge Shackelford, May 30th, 2025.
True, Your Honor. We had filed a motion because we did not believe the plaintiff's small claims complaint complied with the court rules or stated any type of cause of action. Judge Shackelford disagreed and interpreted that there was a breach of contract and a fraud presented in that one paragraph in the small claim complaint. So we did discovery based on that, and discovery has completed. And now we filed this motion to dismiss. And I can go through, you know, the exhibits and the arguments if we like.
Well, what's different now than before?
Well, it wasn't on the merits before, Judge. It was a motion to strike based on C8, because MCR 116C8, because we did not believe they stated a cause of action. They have to plead and prove all elements of both causes of action that the judge interpreted. And they have not. They didn't amend any complaint. And even if you interpret the complaint to state those causes of action for breach of contract and fraud, we have our motion today is based on MCR 2.116C10, there being no genuine issued material fact, because the basis of defendants, the basis of plaintiff's complaints is false, and the plaintiffs did not even respond to the motion and counter any of the evidence that we've provided. They can't do that in oral argument. They presented the court no form admissible evidence. Once we file our motion, the burden shifts to the plaintiffs to establish a genuine issue of material fact. They have not done that. But even if they tried to, because the paperwork is very clear. Essentially, Judge, what they've done, they complained in their complaint that they claim my client sold them a brand new engine for their vehicle, and that claim is false. And I think that's where you can potentially argue, let's say, breach of contract or fraud. My client has offered an affidavit, and we actually present the plaintiff's receipt as our Exhibit 3. If you look at our Exhibit 3,
you know, I don't, did you file it? I don't even have a copy of your motion, I'm afraid.
it has been filed, Your Honor, and it's something you do want to read before you make any kind of ruling. I mean, if you want to take arguments today and review it later, or just simply adjourn it, either way, whichever your pleasure is, but it was filed and it was scheduled, and the court did note, I noticed it for hearing, and the court sent another notice for that hearing as well. And it was noticed, it was originally noticed in September, but it was adjourned for some, to today's date. September 18th is the first notice for both summary disposition and settlement conference, and then it was adjourned to today by a notice dated.
So, Mr. Johnson, you filed this in small claims court.
Yes.
Did you file an amended answer?
Well, I don't think that I filed in small claims court. I filed evidence with photos and receipts and stating of odometers, a mileage of the vehicle, and the false claim that they sold us a remanufactured motor. When we spoke with the man Bush there at Elite Auto Care, he was going to say that we was going to receive a new motor. We paid extra money out of pocket for a new motor. And as you see, I don't know if you have the photographs for the. As you can see, we have the new motor that has serial numbers and various all over the motor. And on the old motor, there's no serial numbers. There's no type of tag stating that it was from Elite, stating that it was a new motor. There's nothing. We didn't get a warranty package or anything. And the motor failed within 40,000 miles. And you know, you pay all that money for a new motor, you're not like it fails within 40,000 miles, John.
All right. Yeah, I don't have your motion. Unfortunately, I don't know.
Okay, I don't.
Well, I don't have that defendant's motion.
Yeah, it's there. It was filed. I got a stamped copy showing that it was filed by the court. It was filed on 8/14/2025. And keep in mind, Your Honor, these are electronically filed. So I don't know how the court keeps its records on that.
All right. So I think Judge probably should go back to Judge Shackelford anyways, since she was the one that originally ruled on your motion for summary disposition and denied it.
Yeah, again, that was a motion to strike for not conforming to the court rules. This is based on the lack of merits in C10. You want to give us a new date?
I don't know if it was it all e-filed or? We'll give you another date. It'll be mailed out.
Do you know what that date would be, Your Honor?
No.
Your Honor, I don't understand why we study going from date to date when we originally had our first date back in June, I believe, or July. And now here we are again. We had another date scheduled back in September. That date was canceled. Now we're here today, and you know we got a snippet evidence that motor was not brand new, and the attorney knows it, and Bush there at Elite Car Care knows that he sold it as basically a used motor. We didn't pay for the used motor. We paid for a new motor.
So I don't, I don't even have his motion to look at.
Judge, the civil clerks are printing it and sending it up,
They're bringing it up.
but they're sending.
All right. Well, if you want to hold on a minute, they're printing it up and they're going to bring it up for me.
Okay.
Just place you back in a waiting room. Did you file an answer, Mr. Johnson?
I'm sorry, I didn't understand anything about an answer to the motion. I just figured that we got to wait till the court date today. So I would have knew about it, filed an answer to it. I would have came to the courthouse and filed an answer.
So you're arguing that, what evidence do you have that you bought a used engine and not a new one?
Well, the evidence I have is I'm going off of the receipt from what Elite Car Care stated, and as well as when my new mechanic pulled the motor out, which I was there when he pulled the motor out of the vehicle, we seen that it was not a new motor. It was spray painted. It was spray painted with silver paint. to make it look like a new motor, and we checked for various serial numbers on the engine block, and we did not find any serial numbers on the engine block. As stated, when the new motor arrived that I purchased, it had serial numbers and that matched all the paperwork and everything. Only thing that I have from the attorney stating it was an invoice for a specific motor size, which can go to this particular motor that we're speaking of can go into 5 different vehicles that GM made. So we don't know if that's our motor, that's our invoice for our motor or not,
The one I attached, the one I attached is the one they produced during discovery and the one they signed. And it says specifically, and I can show it to you when you get a copy of the motion, I'll point it out to you because I did highlight it, that in 2 different places that the customer was to receive a 3-year, 100,000 mile warranty on a remanufactured engine. And keep in mind, they had some type of insurance policy for their vehicle. Their insurance company, as my client explains in their affidavit, which I've attached, only provided for a remanufactured engine. That's all they would pay for. They paid their deductible, the insurance company paid their amounts, and everybody was on their way. You continue.
Check for that, Your Honor.
I apologize for interrupting, Your Honor, but if I could just finish.
So let me let me read the motion at this time.
Okay.
Well, all right, Mr. Johnson, which I have 2 sets of pictures. There's one that that's looks like it's broken into a number of different photographs.
Oh, yes, collage, yes, sir.
Is that what you submitted?
Yes, I submitted that one, yes.
There was nothing submitted in response to the motion, Your Honor.
So
I submitted all the evidence that Judge Shackelford asked me to submit over to him that I have via email to the attorney.
why did you believe you purchased a new engine from Elite Car Care?
On the invoice is the reason I believe because and also on the invoice states that I have a new motor, and
What did you include an invoice or
We did
what?
we did as part of our motion. It's within Exhibit 3, attached to my client's declaration.
Where on that invoice, Mr. Johnson, does it state a new engine?
under labor description, if you look down to where it says
On what page would that be on?
page 2 of 2.
Okay. And it says that,
We're under the second towards the middle of the paragraph where it says remove and replace engine assembly and transfer all accessories to new engine. Refill engine oil with new engine oil and install a new engine oil filter, refilled and bled cooling system and tested, ran after repairs and tested good.
okay.
So
All right. Yeah.
if you take a look at that, Judge, that is simply distinguishing the old engine from the new engine that was installed. You take a look at page 1 of the receipt, which is again attached as Exhibit 3 to my client or to our motion. Exhibit 3 is my client's declaration explaining all this. But attached to the declaration on the very first page, under the upper left side at the kind of the bottom, it says engine assembly parentheses EMAN, standing for remanufactured. Then it says 3-year 100,000 mile warranty on engine. More clearly, the bottom right of that first page, I've highlighted it. I don't know if your printing came out with the highlights, but it says customers pay additional cost of remanufactured engine and a $100 deductible. And then it goes on to state what the warranty is. The warranty is 3 years, 100,000 miles, or 1 year, or 12,000 miles on labor. This was done in 2020. 3 years takes you to 2023. So their warranty period is over with in 2023. It doesn't extend to 2025. Notwithstanding, it says very clearly it's a remanufactured engine. To point to language that's trying to distinguish between the old engine and the newer engine that was put in, it doesn't suggest that my client's made a representation that he's getting an original OEM part, original equipment manufacturer part. My client states in his affidavit, as you can see, they don't make new engines for old cars. They don't keep making engines forever. They're remanufactured, and the plaintiff had insurance. They submitted this all to his aftermarket insurance company. Insurance company would only pay for remanufactured engine. He states that specifically in his affidavit, and that's exactly what he received. He couldn't give a new engine even if he wanted to.
All right, well, thank you. Mr. Johnson?
Yes, sir. So,
All right, go ahead.
So I disagree with Attorney Graham. It's because they do make new engines still for those vehicles, and I purchased one. It came in a crate. And they, a new engine. They call them crate motors, and they're not remanufactured. And they still make them, and they all have GM parts. As you can see, also on the picture, the reason also I believe it was a used motor is because it had two different parts in the motor. One was from a rock frost placement engine part, and the other one was like a GM part. So they wasn't the same manufacturer company, coming from a new motor. If it stated it was a new motor, it would have the same manufacturer on there. It was parts inside that motor. It's in the pictures. It's just a little hard to see. I apologize. They don't have two different companies on there.
He's arguing that the invoice page 1 represents that you were purchasing a remanufactured engine.
Plus,
Yeah,
you're
I see
on,
that. But I also see that I'm arguing the fact that it was a new motor because me and Bush discussed that, and I said I understand that. He said, well, if you pay a little extra, I can get you a new motor, and that's why I had to pay roughly an extra. I believe it was $1,756 out of pocket for that new motor. That's
All
why.
right.
Judge, if you don't mind me just replying, and I apologize because if he had any arguments or law or evidence, that belongs in an answer to a motion. I don't care if he's
Mr. Johnson, you want to raise your right hand? Do you swear or affirm the testimony you already provided was truthful?
Yes, sir.
All right, thank you. Go ahead, Mr. Gale.
Yeah, again, that doesn't cut it, Your Honor, swearing to information verbally, because a motion which comes forth with evidence shifts the burden to the plaintiff to establish any genuine issue of material fact. My clients clearly have established that he purchased and paid for a remanufactured engine. He supplied nothing in response in admissible form that can be relied upon by this court. That's simply our law. I had a chance, if he would have filed an answer appropriately, I had a chance to reply to it, which I never had a chance because there was no answer. To sit and make oral argument, testifying as an alleged expert, even though he didn't qualify himself as an expert, saying they make new engines for old vehicles and so on and so forth. I mean, I have no chance to reply.
Can I stop you both just for a minute? I'm prepared to rule on your motion.
Sure.
So thanks for allowing me this opportunity. First of all, I've got to point out that Judge Shackelford already ruled on a part of this motion, stating that the plaintiff had stated a cause of action and denying your previous motion for summary disposition. So this really is, in that regard, already settled. I guess the other end of the motion would be no genuine issue of material fact. And in reviewing a motion of that nature, have to review it in the light most favorable to the non-moving party, of course. And that would be Mr. Johnson. And in this case, the invoice appears it could arguably be considered vague because you have two different terms being used. There, you remanufactured engine and a new engine. And contract law generally requires that the contract be interpreted in the case of inconsistency in favor of the non-drafting party, which would be Mr. Johnson. So I think there is a question of fact here that needs to be resolved at a trial because of that. I see the inconsistency in the invoice written by the defendant in this case regarding remanufactured or new engine. I'm relying upon, of course, in deciding this, Mr. Johnson's testimony. So, yeah, I think the issue of failure to state a cause of action has already been decided by Judge Shackelford. And the issue of no genuine issue of material fact has to be decided in favor of the defendant in this case. So for the reasons stated, I deny motion for summary disposition. Therefore, this is, I guess, I don't know if you want to move into a settlement discussion today or just have it set for a trial.
Yeah, I mean, I don't think this matter can be resolved, Judge. I think a trial date would be appropriate.
All right. So, yeah, Mr. Johnson, this is the date you'll need to bring in any mechanics or witnesses you might have. You'll be unable to testify regarding what someone else told you. You'll need to bring in your documents and witnesses to support your case at that time and any other evidence you might have.
Okay, Your Honor.
And we'll set it, this is a bench trial.
It is, Your Honor.
So the clerk will send out notice of that bench trial.
Okay. I mean, I've got a schedule. Is there any way we can get an idea of when that would possibly be? Because I'd hate to keep filing motions to adjourn or if there's a conflict.
Well, yeah, I don't know your schedule. I don't know the court schedule.
Yeah.
You'll just have to, I guess, address that when the notice comes out.
Okay. Thank you, Your Honor.
All right. All right. Anything else?
That's it.
All right. Thank you.